Frustration of contract and force majeure clauses both deal with unexpected events that affect contractual performance, but they operate very differently and can significantly lead to legal consequences if misunderstood. A force majeure clause is a contractual provision that sets out what happens if extraordinary events outside the party's control prevent or delay performance. Common examples include natural disasters, pandemics, war, government action, industrial disputes, or unforeseen events. Because force majeure is entirely contractual, whether it applies depends on the wording of the clause itself. Some clauses suspend performance, others allow additional time to perform, and some permit termination if the event continues for a specified period. By contrast, frustration is a common law doctrine that applies even where a contract contains no force majeure clause. A contract may be frustrated where an unforeseen event occurs after the contract is formed that makes performance impossible, illegal, or fundamentally different from what the parties had originally agreed. The event must not have been caused by either party, and it must go beyond merely making the contract more expensive or less profitable to perform. A common misconception is that financial hardship or increased costs automatically frustrate a contract. In most cases, they don't. Courts apply the doctrine of frustration narrowly, and commercial inconvenience, inflation, labor shortages, or reduced profitability will rarely be enough on their own. The threshold is high because frustration brings the contract to an end automatically, without either party electing to terminate. Where frustration is established, the parties are generally released from performing future contractual obligations. However, rights and liabilities that accrued before the frustrating event may still remain, and issues such as payments already made, deposits, and expenses incurred may need to be resolved under the applicable law. Many commercial contracts contain force majeure clauses, specifically to avoid uncertainty about frustration. A carefully drafted clause can define what events are covered, and notice must be given whether obligations are suspended or terminated, and what happens in the event if the event continues for an extended period. Because determining whether a contract has been frustrated or whether a force majeure clause applies depends on the wording of the agreement and the specific facts. These disputes often involve complex issues of contractual interpretation. Understanding which legal framework applies and whether there is a lawful basis to suspend, vary, or terminate contractual obligations can significantly affect the outcome of a commercial dispute. Contact us today for a free 30-minute consultation with one of our experienced team of commercial litigation professionals, and let us help you protect your rights.